Welcome to The Explainer, where we break down complex stories using the original source material. And today we're diving into some serious neighborhood drama, the kind that ends up in court.
So, let's get right to it. Can your HOA hold a secret meeting? One you're not invited to? Well, we're going to find out by looking at a real court case. This is a dispute between one homeowner and his homeowners association that went all the way to a hearing. And believe me, this isn't just about petty neighborhood squabbles. It all comes down to some really specific legal rules.
All right, so our story kicks off in Tucson, Arizona, in a community called the Saguaro Crest subdivision. And here we meet our main character, a homeowner named Clifford Burns. Now, Mr. Burns had a feeling, a suspicion, that his HOA board was making some pretty huge decisions behind closed doors, and he wasn't about to just let it slide. He took action and filed a formal petition. And we're not talking about a disagreement over the color of someone's mailbox or, lawn ornaments. No, this was way bigger. The HOA board was actually thinking about dissolving itself entirely. I mean, just imagine that. A move like that would send massive financial and legal shockwaves through the entire community, affecting every single person who lived there.
So what was at the heart of all this? 18 acres. 18 acres of common land. And as the homeowner argued, this isn't just some patch of grass, right? It's a huge community asset. We're talking about something that directly affects zoning, tax benefits, and everybody's property values. It's a really big deal.
Okay, so here's a quick look at how this all played out. You can see the key dates, but really this entire fight, it all boils down to one single day, May 31st, 2022. That's the day the HOA board had a meeting that Mr. Burns said was held in total secret, which he argued was a direct violation of Arizona's open meeting law.
So picture this. The big legal showdown doesn't happen in some grand wood-paneled courtroom. Nope, this all went down in a virtual hearing over Google Meet. And the person presiding over it all was Administrative Law Judge Velva Moses-Thompson.
Right from the get-go, the judge made things crystal clear. She said, "Look, we are not here today to debate whether dissolving the HOA is a good idea or a bad idea. Her job, her authority, was laser-focused on just one thing. Did the HOA follow the proper legal procedure for that one meeting on May 31st? That's it. Procedure was everything."
All right, let's get into the homeowner's argument. Mr. Burns actually represented himself, which is pretty incredible. He stood up and laid out his case, basically arguing that the HOA board had just completely ignored its legal duties to the people it was supposed to represent.
He basically said, what we're going to show here today is that there has been a closed meeting, an unnoticed meeting to discuss how this land is to be gotten rid of. He's saying this secret meeting was all about figuring out how to ditch that huge 18-acre common area. And because the homeowners had no idea it was even happening, they never got their chance to speak up about a decision that could seriously impact their biggest asset, their own homes. So his case was actually pretty simple. He said, look, the law in Arizona is clear. HOA board meetings have to be open to all the members, and you have to announce them at least 48 hours in advance. He alleged this meeting didn't do either of those things. It wasn't open, and it wasn't noticed. Simple as that. Okay, so now for the other side of the story. The HOA, represented by their attorney John Crotty, had a completely different take. They were adamant they had followed the law perfectly and that it was Mr. Burns who was, getting the rules all wrong. Their whole defense, and this is really the key, it all rested on one specific part of the law, what's called the legal advice exception. They argued that, yes, the meeting happened, but its only purpose was to get confidential legal advice from their attorney about this whole dissolving the HOA thing. And under Arizona law, that's one of the few reasons you're actually allowed to have a closed-door meeting.
So you see the clash here, right? It all boils down to how you define this get-together. Was it an official board of directors meeting? The homeowner said yes, because 2 of the 3 board members were there. That's a quorum. And they were talking about HOA business. Or was it just a meeting with legal counsel? The HOA argued it was just an informal chat with their lawyer, so the normal rules about giving notice just didn't apply.
But what did the HOA's own paperwork call the meeting? This is where things get really interesting. During the hearing, Mr. Burns directed the judge's attention to a key piece of evidence he'd submitted, a document that came straight from the HOA's own files.
And there it is, Exhibit D, page 5. The title? Board of Directors Meeting with Legal Counsel. Wow, their own meeting notes from their own records called it a Board of Directors meeting. You can imagine that was a pretty big point for the homeowner's case, and definitely weakened the HOA's claim that this was just some informal legal consult.
So, after hearing from both sides and looking at all the evidence, Judge Moses-Thompson was ready to make her call. And let me tell you, it was not a simple win for one side and a loss for the other. The final decision was actually pretty nuanced. Okay, let's break this down. The judge basically split the baby. On the first point, was the meeting illegally closed? She actually sided with the HOA. She said because they were only getting legal advice, it was okay for the meeting to be private. But on the second point, was the meeting illegally unnoticed? She sided with the homeowner. She ruled that the law requires notice for all board meetings, even the ones that are legally allowed to be closed. The HOA completely failed to do that. And because the homeowner was what they call the prevailing party on that huge issue of the notice violation, the judge ordered the HOA to pay him $500, basically to reimburse him for his filing fee. So what's the big takeaway here? I mean, why does a fight over a single meeting's notice really matter? Well, it gets at a really fundamental principle about transparency and how any community should be run.
What the judge's decision really did was reinforce this core idea: transparency matters. The whole point of these laws is that meetings in a planned community should be conducted out in the open, with notice given to all the members. It's designed to make sure everyone is kept in the loop.
So here's the bottom line, the legal takeaway. Step 1. Yes, an HOA board absolutely can meet privately with their lawyer. But, and this is the crucial part, Step 2, they first have to give members notice that the meeting is even happening. And Step 3, that notice should probably say that the meeting is going to be closed and why. The ruling makes it clear. A board might have a right to privacy for legal advice, but they do not have a right to secrecy. Procedure is everything.
You know, this whole case was decided on what might seem like a tiny procedural detail. But it leaves you with a final thought, right? What are the small rules that govern your community? And are they actually being followed? It's just a powerful reminder that governance, whether it's for a whole country or just a neighborhood, is really built on these small but absolutely essential details that are designed to ensure fairness for everybody.